acquisition subject to the existing debt. We deal with wraparound mortgages when we're buying as well as selling, and things of that nature that are out there. And every once in a while, I mean, there's a myriad of blended things that come up. There's a first lien. All of a sudden we find a second and third lien, maybe a fourth lien. And then somebody's putting a private lien on it. And, you know, things of this nature happen out there. But just to kind of start the conversation off a bit, guys, what do you see that would be the better, what can these guys do to help us help them better getting the ball game going? What's the first thing that comes to y'all's mind?
Get all your information in at one time.
No piecemealing.
Oh, wait. You know, I want the marketplace to understand that we're not dealing just on one deal. And so often a lot of investors think we're working on one deal only and that's it. And we should know everything they're doing, start to finish, every moment of the day, right? And I get it because it's important to them and it's important to us. But but they're dealing with one and we're dealing with 100.
Right.
And when you start and stop, I don't know about you, Tina, but it kills me.
Yes.
I have to go back and relearn the whole daggum thing over again.
Mm-hmm.
And it's just like, oh my gosh. Because now I'm trying to figure out what we talked about last week or the week before, because it just trickles in.
Mm-hmm.
So how can they get this information coming in quicker? What can they do to provide it to us? Let's just talk a minute about an acquisition. Now let's talk about, because we see so many of are subject to deals. Let's just use that as an initial topic. So on a sub 2 deal, and they bring us a deal, you know, we see here in Texas, we see a lot of TREC, or our standardized contracts, and we see a lot of, I'm going to go ahead and use sub 2 type contracts from Pace Morby's group, and others, everything from a one-page deal to whatever it might be.
Mm-hmm.
But when the investor gets the deal out there under contract, what do they need to get to us that first time out of the chute to help us get the ball game going? What would y'all say?
Initially, as in maybe like the process and procedure form, getting that information into us immediately, because it gives us the information that about the buyer, the seller, and the type of loan that it is, so then we can better guide them into what documents that we need for the file.
Just tell everybody out, we have what's called a process procedure form that when someone calls in to get the ball game going, boom, we send that out to them.
Right.
And that has all the information. Those are the magic hands that just show up out of nowhere. Isn't that neat? Okay, I got it like a third of what we need.
Right.
Or a half. So then you gotta go back and start over again, right?
Mm-hmm.
Oh, I get it. But you know, one of the things we try to do, unlike most other closing agents I know of in Texas, really anywhere else, is we really try to provide quality disclosures for the creative finance world to our investors when they're buying and or selling a deal, right? But we can't just look at a contract and fill them out sometimes. You need more information. So what is it they need to get to us? What do they need? What's that first thing what do they need? I get the P&P form, as we call it, the process procedure form.
Mortgage statement.
So the most current mortgage statement.
Correct.
And guys, that means a mortgage statement, right? Not a computer printout.
Not a payoff. Or a screenshot from their phone.
Not a payoff, or something like that. It's true, unless it's actually a copy of the actual mortgage statement. And you gotta look at the date, right? Don't send us a 3-year-old mortgage statement. Doesn't do us any. Now, that might use some basic terms, right?
Yeah.
But if you guys are getting a mortgage statement real quick, you know, we see a lot of computer printouts that they got off online. Here in Texas, though, we need more information to fill out our underlying lien disclosure notice. And really, I like to use that anywhere we do it. You know, we close here in Horne in Texas. We close OFN National Escrow nationally, but we still provide the same forms because it's a smart thing to do, right? I like providing the underlying lien disclosure notice and the insurance disclosure notice, which are mandatory here in Texas, to be provided anytime a loan's being left in place. And even though in other states they don't have that, would you say it's a good thing to include?
Yes.
Yeah.
I have a scenario for you though. I had
Okay.
someone reach out to me the other day and they said, well, if I disclose everything, then I find that it blows up my deal because the buyer's finding out I'm making money off the transaction. How do you respond to that?
It's okay to make money. You know, I would say two things. So, you know, what we do is I always tell people all the time, we are not the mortgage police.
Right.
Sharon is the mortgage police, okay? And by the way, guys, y'all don't know this. This is our stickler for details, which is phenomenally awesome all the way through because you have to have that. No, sometimes I gotta unwind her a little bit, but you really want that because that's what keeps all of us protected and our noses clean, no matter where you are. It's really important to have that. The mortgage police. We'll have to get you a little banner sign for that somewhere for your office.
MP.
But it's true, and it's great because you really learned this business so well over the last, 10 years now. I mean, I remember sitting here for 100 times with you going through closings and whatnot. You just picked it up, asked a bazillion questions and went through it all. But I kind of got lost there for a minute. You know, when we prepare a disclosure package, that is really a courtesy because we don't, you know, for Tina and I here. So guys, you don't know it, Tina is our other attorney extraordinaire over here who's really the smart one of the group. I just have the gift of gab to talk too much. But,
True.
you know, where was I going? Poof.
Disclosure.
Her question.
No, with the disclosures, the marketplace does not have to use them. We provide it as a courtesy only. Because we rarely, if ever, represent a buyer or a seller, whether it's acquisitions or sale, whatever it might be, right? Nobody wants to pay the extra money, and we're going to do our best to explain things anyway. That's just the nature of the beast that we try to do around here. But, you know, if they don't want to use the forms, they don't have to. If they want to interline and change the forms, go for it. We don't care. The liability rests on either the seller, the buyer, whoever the transaction's with, not us. We're just trying to make sure everybody has what they need and they can pick and choose from there. So my answer would be is, you don't want to include it? Don't do it. Now in Texas, you don't have an option. Mandatory. Mandatory. That means you got to use it, guys. You know, that's property code issues. There's Texas finance code issues. There are just things you have to do in Texas. But other states, not so much, right? But they had the option to use forms, pull forms out, change. We don't care. Sharon cares. I'm picking on you now.
I see.
But, you know, it really does it. So and my answer is if you want to use it, use it. You don't. No. No skin off our nose, right?
Right.
So that would be my response usually. I think it's smart to have it, and it shouldn't kill a deal for any reason whatsoever. That's okay though. But you know, you want your borrower to know what's going on. If you're doing a wraparound loan, let's say, you better make sure you're disclosing the underlying lien on the property, which can be researched, which is public record, which can be found. And if they start asking you questions, you can't hide it. So you got to disclose it. And I just find, as the nature of our beast, the more you can disclose, the easier it makes the deal, the cleaner it makes the deal, the less liability you have. Yeah, you want liability?
Nope.
I don't. Yeah, me either. You know, me no like lawyers. Lawyers are bad. Keep lawyers out of the picture. We're good lawyers because we're the transactional guys. But it's them litigators you don't like, right?
Those are the ones that cost a lot of money.
Yes, they do. So what I've heard so far is, you know, try to get the information in so we can look at it because it really helps us to. We still have to look at the contract and know what's going on and what are the underlying terms. what else should they try to get to us up front if possible?
Their engagement fee,
Yeah.
so we can get title
Better
rights on
Yeah.
whatever ordered.
So what's important about that from our end?
The quicker we get it back, the quicker we can get moving.
Yeah, but the problem is the moment we order an abstract, guys, we got to pay for it.
Right.
It doesn't matter if the deal closes or not, so we don't want to get stuck with that payment. You know, I go back, and one of the reasons we have that in our repertoire is, the audience doesn't know this, but I'm an old surveyor engineer, my dad was too, and I would see him run 10 survey crews, and their deal with the title companies back then was the deal didn't close, they didn't get paid, but they got all the business. But as it wasn't right, if you do the work, you deserve to get paid, whether you're a surveyor, appraiser, or what it might be. But once we order that abstract, whether the deal closes or not, you're paying for it.
Right.
So I mean, that's why we want that money up front. And a lot of people go, why? Well, that's why. Now they can do their own title search. We don't have to do it, but that's going to be an agreement between the seller and buyer in that regard. And you know, again, buyer beware
Right.
in those situations. What's that Latin term?
𝐬𝐴𝐧𝐿?
Very good. Look at that. You know, we'll talk about res ipsa loquitur and those kind of things later. You know, we'll do a nunc pro tunc. That means this for that, by the way. Big fancy words. We lawyers like to use, you know, quarter words, not nickel words. Yeah. So anyway, they don't have to use the docs, but we think it's best to do it, right?
Right.
So, get us the mortgage statement. What else? Oh, come on, guys. Y'all know this answer. Copy of the
Contract.
notes. Well, the contract, obviously.
Contract.
The mortgage
Okay,
statement.
send that in
Complete
first.
contract. Yeah, a
You know-
complete
TBD.
executed contract.
Say that again?
Not a TBD
To
sales
be determined.
price.
Yep. So a lot of guys put that in there. It's like, well, read my mind, right?
Yeah.
Uh-huh.
And we see that all the time.
All
And it's
the
just
time.
like, don't do that, guys. We don't want to read your mind. You know, but I like to see a copy of the note and deed of trust.
Right.
Right.
Not that we have to have that, but that deed of trust is kind of important. What's the information we glean out of the deed of trust? So we can draft our paperwork?
Trustee,
The trustee, right?
recording.
And it tells us the original terms of the deal that we have to know.
Right.
You know, I don't think we're going to get recording information because the odds are we won't get the recorded deed of trust. That's going to come up in our abstract. But it's nice to see the actual document out there. And you know, in the investor world, investors need access to that information. They need to look at that deed of trust because if there is a potential default down the road somewhere, maybe what does that default look like? Is it a 20-day notice, 30-day notice? You need to understand what's out there. So you actually want to read it one time. If you're going to buy a property and take a property subject to the mortgage, you need to know what the mortgage actually says.
Right.
If you're going to have the obligation to take that over, how many people do you think actually do that and read it? 0.3% maybe? Or is it less? But it's a smart thing to do. So I see this stuff, guys, and you know, I need y'all to speak up because you guys really deal with this stuff all the time. It is, get us the contract. If you're buying it sub 2, get us the mortgage statement. Make sure the contract's complete. If you have, by the way, you can't always get access to the note and deed of trust. We understand that.
Right.
If you can, it's a good thing to do. Or have the seller maybe order it online. They can order that from the mortgage company and get it emailed to them pretty easily, usually. And things of that nature. And if needed, we can order it through, when we order the abstract, we can order the documents. But they might charge a bit more money for that. And everybody wants to argue about that because you have to have that. So all this is really about helping the investor save a little bit of money there as well, if they can get access to it. So mortgage statement, note deed of trust. Now one thing I find really confusing out there is, because they keep sending us the insurance policies from the original seller. I don't need it. That's really for them and their file for that lost payee clause, right? I love the head bobbing. You know, you're supposed to wiggle the lips too along the way. But that is really the main thing. Get us the information the first time. Now, sub 2 guys, you know, we don't have to deal a whole lot with compliance, right? It's just Texas. You know, we have to get the underlying. And by the way, I'm going to make a comment. And this, I think everybody knows this comes from the OFN websites and videos we've done there as well. But, you know, even though the risk is on the seller by not providing the underlying lien disclosure and insurance disclosure notices, it doesn't mean that we as the investor buyer, and I'm pointing to me because we're an investor too, shouldn't help our sellers comply.
Correct.
Right.
They have no clue what the law is. And we should know what it is and make sure that we protect them from themselves the best we can.
Right.
That's just the right thing to do out there. I know we promote doing the right thing wherever possible, right?
Correct.
What's another thing that's out there that y'all see?
HOAs, I think that people forget to ask if they're in an HOAs and to pull the resale certificate, and that usually holds up the file a lot as well.
Yeah, what's the issue of HOAs today? They want you to pay for everything up front,
Yes.
just like the abstract. So again, we usually ask the buyer or seller if they can arrange that or orchestrate it and then get it to us. Because again, the last thing we want to do is order it, write that check for $250, $395, whatever it might be. Deal doesn't close, and all of a sudden people go, "Oh, I'm not paying that."
Right.
And that's what we try to prevent. So I hope everybody understands that we do all these things just because we have to. It's not because we want to. They didn't used to have to do that in the HOA world, by the way, guys. It used to be the title company, closing agent would just order it and it would be collected at closing.
Right.
But I'm guessing that they got the same issues that we have going on, that time, effort to do all that kind of stuff. They're going, we need to get paid for this if it doesn't happen. And I get it. But there's just some costs and expenses that are incurred in the business. It's just the cost of doing business, right? And guys, if y'all know me well enough, I'm an investor. I'm cheap. I don't like paying for it either. And thank goodness Susan Terry's not here because she would amen that one probably. So once we get this in, what else can the investor do really to help themselves move this thing along quicker?
Well, if they're doing an assignment, we need an assignment agreement as well.
If they're doing an
Need you
assignment.
guys to speak up a little bit. Scott, you're good.
If they, maybe I have it
That's
too
not coming
covered.
from that. You're gonna talk towards that.
On this one?
Yeah.
Oh, jeez. If they're doing an assignment, we need an assignment agreement.
Yep.
Like in advance, no after we already prepared the documents. That's probably a good idea.
So we know who's actually buying it,
Correct.
changing the terms.
Yeah.
Right.
Because we're going to draft documents
Change the buyer's name.
based upon what the contracts say, right?
Correct.
Yes.
Or the assignment.
Mm-hmm.
We ain't going to be mind readers and going, well, you meant to do this, right? Well, you should have known that.
Yeah.
You know, why didn't you know that?
Right.
You know, Tina's a mind reader.
She is.
No.
I'm looking for classes, but I have yet to find them.
I got it. So I get the assignments. What is your thought, real quick, on assignments of contract?
In what context?
I mean, with people who do assignments and want to stay involved in the transaction.
In my mind, if you're doing assignments, then you're stepping out of the transaction. You're just collecting a fee at the closing.
Or whatever the document says, right?
Right.
In advance at closing sometime.
Right, yes.
Does that usually happen, though?
No, they still want to be involved.
They want to control the whole deal.
Yes.
So I guess the rule there is to learn that when you execute an assignment, you're done, unless the contract reserves you have those rights to maintain that relationship and information flow, etc. But otherwise, you're out of the deal.
Right.
Right.
Do you think investors like to hear that?
No.
No. That's an easy answer, isn't it?
Yep.
They throw a fit. It's like, what do you mean? Well, it is what it is. You've assigned away your rights. So again, I think there's a little bit of knowledge is power. And we see some good assignments, and we see some bad assignments. I got it.
They need to be very careful with their assignments on how earnest money is handled as well.
Oh, because when you assign a contract, you're assigning everything, right?
Yes.
Now, grant you, I see so many contracts for $10, $100. The earnest money's small, but sometimes you see $1,000, $2,000 earnest money's bigger occasionally.
Yes.
And when you assign that contract, it goes with the assignment, so you better have that built into your assignment fee, right?
Correct.
And you can't go back and go, oops, I didn't mean it that way. You know, maybe your back-end buyer will agree to it, but not always.
Right.
They don't have to. I guess the devil's in the details, isn't it?
Yes.
And it's not quite as easy as everybody thinks it is by talking to your neighbor who's another investor, talk to another investor, and you got some form off the internet, and you think it's okay, not always.
Right.
Make sure you know what you need to do, what you need to say. Make sure your document has it in it. Right? Yep. What else?
On sub twos, it's we've seen that they wait to the last minute to order the reinstatement, which usually takes about 10 days. So that's important to know if they're behind and need a reinstatement, so that way we can have it and make it good through far enough along to where it doesn't expire and we have to order a new one. Because that's something that we see that holds up our files a lot.
You know, I often tell investors, and we'll just table it here real quick, is that when you go to contract day one with your seller, and you know that that seller is you know, in a pre-foreclosure mechanism, right then and there, get the seller to get on the phone with the lender or the law firm, help them out, order the reinstatement immediately, have it sent to your email, your, I guess fax is still used, your fax, whatever it might be, so that you can control it and you can get that moving along faster. But if you wait to the last minute, especially pre-foreclosure, that's a problem. Now, we're going to stop and help you try to figure out what that fee is, meaning you're most likely going to overpay a little bit if you want to get it closed and stop the foreclosure.
Right.
And you know, again, that's not a science. That's just, you know, as we call it, a wag. What's a wag?
I don't know.
A wild ass guess. So while we're talking scientific, what's a swag? I just gave you the answer.
A stupid wild guess?
A scientific
I don't know.
wild ass guess. These are important legal terms you got to understand, okay?
I'm writing
I
them
missed
down.
that one in law school.
You didn't have that class?
I didn't have that class. I missed that one.
Acronyms, you missed that, okay? I got it. I'm sitting looking at my cheat sheet here a little bit because I think it's important just to go over some things out there. I'm still trying to get to one more point with you. What's the next one?
One more point with us?
How about the terms
We would
that
always
change
ask them the
constantly?
Yeah.
Yeah,
Yeah.
for sure. Yeah.
You know, I want to do it this way. Then it's like, I'm going to pay the seller X. No, I'm going to pay the seller Y.
Yeah.
Oh, no, we're going to pay the seller Z. Well, now there's a realtor. Well, we're going to pay them something too.
Yep.
Oh, we might have a transactional coordinator. We got to do that, right?
Right.
So get it down. Oh, we're going to use a private loan as a second, third lien. And then those terms change. And you know why I find it so
Or
funny?
you get the contract says, oh, we're paying cash. Oh, no, and at the last minute, right before closing, oh, no, we have a lender.
We have a
Yes.
private lender.
So it is kind of like, I know that in our business, guys, this business things do change. I get it.
Yeah, we get it.
And I think the key is for the investor out there is to do your best at getting things set up front. We get it that things change, that's okay. But I think we see things changing way too much sometimes.
It's,
You know, and you know, what's the issue, Ms. Tina, with an investor telling us what their lender's terms are?
I don't know.
So
I'm confused.
if I'm going to tell you what,
they're
at least
not
she's
the
honest,
lender.
didn't she?
Yeah, I'm confused. I don't know what you're asking.
So if the investor says, "Here are my lender's terms,"
Oh, no, we
No,
need
we need it
lender's
from the-
instructions directly
Writing.
from your lender.
kind of like the fox guarding the hen house, right?
Yes.
Yeah. You know, that's just one of the things. It's like, well, this is what we talked about. It's okay. It's like we get it, but you know, we want to hear it from them. Make sure they're good. They're going to wire the money,
Right.
because sometimes these private lenders, they don't know what to do.
Right.
And we got to stop and ask them the questions, send them a form to fill out. Do they want equity? We're not going to have guarantees and those kinds in there unless they specifically request that. You know, your more sophisticated lenders will ask for those kind of things,
Right.
but the average guy on the street doesn't. And we're not here to volunteer that to anybody. That's really up to them to do. But we do need to hear from them on the basic terms. You know, dollar amount. Are you going to fund the whole thing up front? Are you going to hold anything back? Things like that along the way. I just find it so amazing with these private lenders. They go, here's the money,
Yeah.
yeah.
you know, $50,000 all at once.
It's crazy.
Congratulations, $100,000. You kind of go, really? But-
I've had several scenarios as of late where I've had private lenders contact me for foreclosures and they're like, I'm in first lien position, and we end up doing title, and they're not. They're in third lien position.
So how did that happen, you think?
Well, they didn't get title before they lent the money. They
Hmm.
just took somebody's word for it.
Yeah.
I see a lot of that going on, by the way.
Yes.
And again, that's just due diligence, right?
Yes.
You know, it'll never amaze me. I'm gonna take y'all back 100 years ago. You know, well, not 198, okay? And one of our very first investors, Aggie Buddy, who was doing exceedingly, if there's a word beyond that, he was doing that well in the mortgage industry. Phenomenal. And he was one of my very first lenders. He just wanted to give us money, say, here, just do it, just pay me X. I'm going, no, it's going to be in writing. You know, I'm just not going to do that. And he just didn't want to mess with it. He had so much money, he didn't care.
Really?
But even though you have that, it was just like, no.
Yeah.
Get it in writing. Always protect the parties.
Get it right.
Don't go to the temptation of going off the Bahamas or the Azores or somewhere with that money and doing whatever you're going to do with it. You can't go gamble it away. But it's just about being smart, isn't it? And working them out there.
And you talking about going on vacation. We have a problem with
What's a vacation?
buyers and sellers scheduling their closings the day
Right.
before they're supposed to go on vacation. And if there is a hiccup or something wrong that happens with your closing, they're like, what am I going to do? I'm going to be off in some
Different
foreign,
country,
foreign country somewhere. I don't have internet access. Blah, 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 blah. So that'd be another thing I'd advise.
Well,
Don't
you know-
schedule a closing right before vacation.
Oh, I agree with that completely. Fortunately, as we're moving forward on some things, we have the new online notary services, so that at least they do have notary services. We can at least email documents to them. They can go down to the hotel someplace and print them off or whatever it might be. And then at least we can go through an online notary anywhere in the world that would work for them in that regard, at least.
They have internet.
Yeah, and there's going to be at least there should be you hope there's a FedEx somewhere around.
Depends on the
I think I need to go to a place where there's no internet, no FedEx, no nothing. You know, I'm not sure. I mean, that's the bottom of the ocean. I don't know. You know.
Yeah.
What's the lawyer joke about all the lawyers at the bottom of the ocean or whatever it is? There's an old lawyer joke about that somewhere out there along the way. But you know, so a good contract that spells everything out.
Yes.
And sometimes these rinky-dink one-page. I want to make a comment, and I commented in other videos before about contracts. People will come in and say, well, I don't want to use, I'm going to use a TREC contract, a Texas Real Estate Commission, which is a standard contract guys use throughout Texas. And it's like, well, we don't want to use that contract because it's too long and the sellers won't understand it. And of course I go, dude, how do you think your seller bought the house originally? It was with that contract. It may have changed a little bit here and there, but not enough for him. Of course they're going to be familiar with it. And then of course we look at some of the other contracts that are this thick, and it's like, which one's worse?
Right.
Not an answer to that along the way. But sometimes these little short one-page contracts leave so much out.
Yes.
And when a problem does arise, and guys, in this business, problems will arise, unfortunately, at some point in time, you want to make sure you have your rear end covered.
Correct.
These contracts are there for a reason, right?
Yep.
Think about that and think about using them that way. And although I'm going to use the sub-2 contract that's out there, isn't a bad contract per se. It's designed to be a contract to be used anywhere and may leave out certain state-specific issues that your state promulgated form entertains, right? Okay. So I heard good contract. For us, get us our process procedure form. Get us the real mortgage statement. You know, okay, if you don't have it, get us what you can, but work on getting the other one. You can go online, the seller can, and get it, pull it down. You can order it from the mortgage company. There are easy ways to do it if you just think.
Yeah.
Oh, that's a magic word, isn't it? Think. Yeah. They don't do that sometimes. Get us all the info at once. So we have it all here, because that start-stop takes eons of time. And we may be working on 5 other deals as you're piecemealing things in, and we're gonna put you back behind the other one because it's coming in late.
Yeah.
So really, it's there to help them, help get this deal going faster. That's really the goal.
And I don't think they understand that we exhaust every way to get the information. If it's not on our process and procedure form, we'll go to the contract to get buyers, sellers, emails, phone numbers. But then it's not filled out on the contract. So then we're stuck, and then we have to email them and ask them. So it really does stop us.
You know,
but we
one
do
of my
try.
biggies too
What?
is I'll get these emails from investors. It's like, I have a question for you, blah, 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 call me. There's no phone number. They have a name.
Or a subject, the property and the subject line, so you don't know what they're calling about.
I know.
Yeah.
So anyway, I think good information. And then, you know, do your best to have consistent terms up front
Yes.
without changing. We realize things will change, et cetera, but that will substantially help this deal go forward.
Yeah.
Let's talk about another little topic. The TC. What's a TC?
Transaction
Transaction
coordinator.
coordinator.
Yeah, by the way, guys, these didn't exist a year ago
Right.
or so. It just comes into play.
Mhm.
And what really, what I have perceived about that industry a little bit, by the way, it's not a bad industry at all, but having not existed, the people who are coming in to play the game are having to learn the game, and they don't know the game.
Right.
But the investor who's using them thinks they know the game.
Correct.
So what happens?
They rely on somebody that doesn't know what they're doing either.
You get the blind leading the blind, right?
A lot of miscommunication too.
And, you know, again, so often in other states, by the way, guys, I know we have our company called OFN National Escrow. And sometimes closing through OFN National Escrow is so much easier because we don't have all the restrictions and requirements we have here in Texas. I mean, I know Texas is the biggest state, it's the most prolific state for this industry. You know, we got Arizona, Ohio, Florida, Carolinas are kind of right there behind us a little bit. But we're still the most prolific, but we're also the hardest, which is the pain. But in other states, things kind of move quicker and easier because there's just less things you got to think about.
Right.
At least on the acquisition side, you know, from a deal. On the back end wraparound side that we do so much of as well, compliance is going to be across the board, right? We'll talk about that in a little bit. So with the TCs out there, what should the investor know about the TC along the way to help facilitate closings?
Know about the TC?
Yep.
Or just-
Like the experience, you mean?
Well, I think so.
Yeah, if you have a good TC that is experienced in the mortgage industry, I feel that it'll help move the process along. And there's some good ones out there.
There are.
Yeah.
And you know, when I talk to the TC, I'm always trying to help them understand things better.
Right.
And so think about X, Y, and Z, at least here in Texas, you know, for where it might be, because we deal with TCs all over the place. And they may not know the specific rules and regulations for Texas. I don't know if they're taught that or not. I don't know if they're taught anything or how they got that experience level. But I think for the investor, it is understand that your TC may be there to help navigate things for you, but you may have to help navigate the TC also.
Right.
And so many investors want this to be a total hands-off business.
Yes.
I did my job, I found the house. Okay, get it under contract, do this, you do everything else, I'm gone. And it just stops because the TC is floundering out here, not doing things. And then the question becomes, is that TC calling the mortgage company, which we try to avoid whenever possible, if there's a subject to deal going on? You know, I like to do things online, let the seller make the phone calls, but not a third party. I don't like to use POAs or authorization forms if we don't have to. No, the fewer touches. No, in football, you want more touches, right? In this business, you want fewer touches with the mortgage company.
Right.
Do you like that analogy of football there?
I do.
I thought I did a good job with that one for a minute.
Go Chiefs.
I agree. We got a good old Texas, Dallas boy out there. You got to root for that a little bit, don't you? Or are you just rooting for being a Swiftie?
No, I'm not a Taylor Swift fan.
Okay.
I'm a Chiefs fan.
Good. Because I couldn't tell you one of her songs if I had to.
Me either.
Pay me $1 million, I couldn't do it.
I know her boyfriend.
You probably want her boyfriend.
Facts.
By By the way, I don't, just FYI. But it really is just thinking about it for a minute from the TC's perspective. It's like, don't expect them to know everything.
Right.
I hope that the investor knows more than they do. Walk through the process, make sure you're on the same page. What are they going to do? X, Y, and Z. Great. Give them what they need to get this thing going. Then you can get out of the way.
Right.
But at the same time, navigate it a little bit. Don't throw them to the wolves. You know, if they're really good and really experienced, they can probably handle it no problem.
Right.
But that's, you know, it's that 90-10 rule again, unfortunately, is what I see out there right now.
Mm-hmm.
There's still a large learning curve that has to come into play that hasn't gotten there yet in the industry. Okay, so I think those are all great suggestions and ideas along the way. But if you were talking to the investor about the process of a deal from start to finish, walk me through that. What's that going to look like? You got the investor on the phone, you know, what do I need to do? X, Y, and Z. What are you going to tell them?
What do you mean? Like,
How are you going to start?
submit the contract, complete the information, send the process and procedure forms, mortgage statement. I mean, the same process and procedure form has a list of the items that we need. So we still have people asking, what do you need? Even if the process and procedure form says what we need and our email says what we need. So just try to read the document completely, fill it out as much as you can, right? And just send them with the signed contract, the mortgage statement. We need to order it, earnest money, submission fee. We need to order the title run, and then we get the title run. We review the information and get back to you. If there's anything else
Let's
needed.
stop right there a minute about the title run abstract that we get in.
Mhm.
Because sometimes things pop up, right?
Yes.
All of a sudden we see, hey guys, you don't have just one loan, you got two.
You got two,
Right.
three sometimes.
And sometimes that seller forgot about that HUD partial claim deed of trust from their loan mod because they don't make any payments on it. Oops. Or judgment liens, child support liens, solar liens, oh
Solar
my
liens,
gosh.
yes.
All those kind of things pop up, right?
Yeah.
And then we gotta cure them.
Yep.
So I'm gonna ask another question to you guys. Miss Tina, and this is a toughie. So is curing all these defects part of the closing process?
No, it's additional,
Yes.
It becomes
because it requires additional work on our behalf.
Well, it is, but it's gonna be a legal issue, right?
Yes.
Almost every time.
Yep.
Whether it's a probate issue getting resolved,
Right.
Whether it's a judgment lien getting removed, and going through that timely process too. You know, how do we get around a child support lien if it's there? You know, this lien, that pops up, and they do. And you know, sometimes really, really good investors who've done their own research online may know these things in advance. That's great, but so often they don't. And I always tell the investor out there, it's like, guys, when you're in that initial interview process with your seller, know what to be asking. Boom, boom, all myriad of questions about all these kind of things, just to try to head it off at the pass in advance.
Right.
Because anything we can get up front helps us facilitate things faster and go, but doing probate work, that's not part of the closing process. That's a legal issue that either the seller or buyer have to pay for. Clearing a judgment lien is a seller issue that either they or the buyer has to pay for.
Right.
And these are the things that have to be talked about and negotiated, because unfortunately we have to bill for the time. It's just not free. And a lot of this stuff takes a lot of time.
Yep.
I mean, I know everybody wants it to be free, especially me, remember being cheap. So it's getting the contract stuff in, getting that abstract pulled, and looking at reviewing it and clear it off. So once we've got all the paperwork in, we've got enough information to help complete our disclosure packages for them. We have all that back, the abstracts ordered, already been paid for, we're all good. Everything comes in. What's next?
Well, if you've got a underlying mortgage on the property, then that's when we send out the preliminary closing disclosures and the CDF showing the parties what the numbers are, so they have a better idea of what they're looking at closing.
So your closing disclosure? Okay. So really, you know, with a sub-2 deal, you know, I like to tell everybody, you know, minimum 7 days to close, and really I prefer 14 days.
Yeah.
Is what I prefer. to give that seller a chance to review the contract, review the disclosures, seek counsel.
Business days.
Yes.
We don't work Saturday and Sunday, okay?
Well, we don't, but the seller can have the 14 days to look at it from, January 1st to January 15th, and give them a reasonable opportunity, unless you're getting a deal on, the 1st and foreclosures on the 2nd. Okay, different ballgame.
Different.
And I'll make another comment. I don't like jumping through hoops on one day. We've done it before to get a deal closed that's in foreclosure, and there are ways of doing it, but those are stressful issues when you're dealing with that.
Yes.
And people need to be aware that we're going to charge for the stress we incur for those last minute.
Because you gotta drop
Rush fee.
everything you're doing
Yes.
and catapult that to the front all of a sudden.
Right.
Yes.
Yeah, and that is a problem, because guess what? Everybody else is gonna
Everybody
scream
else
at us.
is- Yes.
Well, they want these deals, right?
Yes.
So, contracts all come in, P&P form is in, we got everything ordered up. No, there's been some time now, they've got a closing date set. What do we do?
The docs?
Yeah.
Yeah, we
Yeah.
prepare the docs.
Yeah.
Sure.
So
prepares
prepare the
docs.
mortgage docs, right?
Right,
And all the disclosures go along with that.
right.
I know we do things a little bit different than everybody else, because being an investor who created all the disclosures, I just don't trust sellers
Right.
or buyers. I want to redisclose everything. This is a fail-safe to protect the investor as best we can. So you brought up the CD, the closing disclosure. Is there a little time issue with that too?
Yes.
What's the time issue?
3 days before closing.
How many?
3 business days.
How
No,
many?
sorry, 3 days. 3 days before closing. You close on the 4th day.
If?
What do you mean?
I mean, it's really 6 days. Unless you send it to the borrower and they
Well,
acknowledge
you're
receipt.
supposed to send it to the borrower, get it signed, and then you start counting the 3 days, and you close on the 4th day.
Yeah, you need some way to verify that they have actually received the CD. Then the 3-day period starts. So just because everybody wants to do it, that's a HUD requirement. It's not our requirement for the closing, right?
But
Right.
before that, you have the LE 3 days.
Well, on a sub 2, no. On
No,
a wraparound,
wrap.
yes.
Yes.
We'll get
Well,
there.
you don't do CDs on sub 2s
No.
that much.
Well, no, that's going to be just a straight HUD, which is good.
Right.
So you are exactly right. I kind of jumped over the line there, didn't I? So it's just a basic HUD we got to deal with, which we don't have a time frame.
Right.
So ignore what I just said about that, guys. Even the best of us can get confused every once in a while.
The very, very best.
Albeit
Very,
so
very
humble,
nice.
So I got it. So I think another thing I want investors to know is wherever you might be, investigate your state requirements.
Yes.
Right.
We don't do that for you. Who's going to do that? Who will do it for the investor?
They should do it for themselves.
Yeah.
Well, how? What would you suggest?
Going to state statutes.
Getting attorney.
They're not going to do that.
Or they can hire someone
In the state.
In that
maybe
state.
like us in Texas.
Well, I think what they have to do is you need to either call a title company, really just a knowledgeable real estate attorney, and ask the questions. And
Correct.
no, primarily what I have heard out in the marketplace, there's 22 states that have foreclosure rescue laws. And so if you are buying a property sub 2 and it's in a pre-foreclosure mode, you better know what those are, because there's various degrees from 3 days to 30-day issues. I don't know the details. I don't know all the 22 states, but they're out there. And there's various degrees of issues. If you don't do this right, it can come back and bite you. And we'll talk about other things that can come back and bite you here in a minute also. But know your state requirements, right?
Yes.
Get that done and taken care of. So really the sub 2, direct seller finance acquisition, wraparound acquisition, a little bit easier than the back end sale.
Right.
But let's kind of mosey into the back end.
Can I ask
Self
you
a minute.
real quick? Because
No.
after we sent out the
Did you raise your
did you
hand?
say no? When we send out the docs, we want everyone to review the docs. Because sometimes they sign, they're at the closing table and they're signing with a mobile notary, or sometimes they'll be here in our office and there's something that because we send them out days in advance for them to review, let us know if there's any changes that need to be made, and they don't let us know. And so then we're last minute at the closing table, literally sitting at the closing table, running to go make the changes and do that. Or they're with a notary and asking us to email some. So we would want them to review the documents
You know,
beforehand.
Yes.
I have encountered that so many times where they'll tell you, why did you sign them? It's like, really? Did you even look at what you signed?
Yeah.
You know, I have signed over 27,000 sets of bank documents. 27,000 sets of bank documents.
That's a lot of signatures.
Yeah,
That's
oh,
a
yeah.
lot of signature.
Let me
That's
tell
why
you
it's so
what,
beautiful.
I can sign my name. Do you think I read every word in every document? No. Do you think I looked at
Terms.
property? Do you think I looked at loan amount,
Right.
interest rate,
Sounds
payment
price.
amount, term,
Your name, if it's
fixed,
correct.
that,
Yeah.
name, little details? Yeah. Did I go through and read every little word? No.
No.
Oh my gosh, that'd be
Just
horrible.
the main information.
But you have to stop long enough to look at it.
Right.
Doesn't take long. All you do is look at 4, 5, 6 places, and usually you're pretty good
Right.
to see, did someone just by mistake type in an I instead of an E in your name or something like that? I mean, even though you can interline that and initial it, if we know it up front, you can fix it quick.
The name will be wrong, but if the numbers are wrong, ooh, they'll let us know right away.
I know, they do, and I get all
We
that.
have a few that don't.
I know.
They sign, they send the package, and once it's fully executed, they're like, "What did I sign? What is this?
Yeah.
I don't think this is what I wanted to do."
Or by the way,
Like,
why did I get a check for this amount? It was supposed to be this amount.
okay.
I know.
So
You
just
know,
review the
I
documents.
think I had that
Just
somewhere
review,
where
please.
investors need to learn how to do the math and run the numbers. Is that right?
Calculator.
Yes.
Because I know you scream about that all the time. Yeah.
A little bit.
There are free amortization calculators online.
Yes, please look it up.
So it's easy to run a quick number, right?
Yes.
Yes.
If you have a $100,000 loan at 9% for 30 years, your monthly payment is $786, blah blah blah, right?
Yes.
Or 20 years.
Simple
50.
math.
Do it out there and just do it the right way.
Yes.
But and you know, I'll say one of my pet peeves as we are moving on to the next topic here for a minute is I don't want to be responsible for running your numbers
Right.
in case I mess them up. And you say, well, it's your fault. Well, no.
No.
I want you to get, this is like we want these private lenders to give us their numbers.
Right.
We want the investor to give us the numbers that they want to work off of and go with. And I get on a subject to deal, we have a mortgage statement that tells us what that is. And we're going to rely upon that. But as for those other liens that come along the way, those private liens on an acquisition you want. Now on the wraparound side, when you're doing a wrap loan, it becomes really important to make sure that is correct. They've estimated their taxes and insurance.
Yeah.
Right.
And before we get into the wrap side, I will make a comment for the audience, which is, remember, you're the seller, lender, underwriter, everything.
Mm-hmm.
You are technically the mortgage company.
Right.
There is no mortgage company to tell the buyer what's going on. You can't just have a dollar amount for the loan and interest rate and a monthly payment. You've got taxes, insurance, maybe you're not going to have MIP, mortgage insurance premiums. You may have loan servicing fees, other things that you need to put in writing as an agreement between the parties so everybody understands what their obligations are going to be when you buy the property, right?
Right.
That's do the math also. But it's also knowing what you need to do and how to find that and how to get it, along the way. Here in Texas, a lot of the main cities, like in Dallas, the Dallas County, for instance, will collect county, school, city taxes et al.
Right.
But other little municipalities all around Dallas proper, the city collects theirs, the county collects theirs, and the school district collects theirs. So you got to look in 3 different places to get those numbers.
Right.
But you need to learn not only how to do the math, but where to go get the numbers
Mm-hmm.
to have a good number set, yeah? So, on a wrap, let's talk about compliance for a minute. And compliance really comes into play for every state out there. So what are some of the compliance things that they need to be thinking about along the way that will help get their deal done quicker?
Well, you have the 7 days for the underlying lien disclosures.
So we have that here in Texas.
You have the, yes, here in Texas. You have the 7 days for the 𝐼𝐴. You have the 3 days for the loan estimate.
So the 𝐼𝐴 is the loan processor, because we always
Correct.
suggest you process the buyer.
Yes.
Okay,
And you have the 3 days for the CD.
provided that they've signed off receipt of it.
Correct.
So it's really, and you can close on the 4th day.
Correct.
And these don't always all run concurrently.
No.
You know, here in Texas, which is the tough state, you know, you want to get that underlying lien disclosure notice executed with your contract as soon as possible.
Right.
Get your earnest money. That starts that 7-day running.
But we cannot prepare it. We don't have all the information up front.
Yep.
So,
That's exactly right. So what else are you going to do with all that, though?
with what?
So you've got all that prepared.
Uh-huh.
And next,
The underlying lien disclosures.
so you got that. So you're running. That's running.
Okay.
So
Then you order the title run, review the title run. The 𝐼𝐴 is being, or the buyers are being in process, hopefully simultaneously, right?
Yep. Well, so yes, that's one of the step-by-step processes. By the way, guys, we've got great step-by-step process procedure forms on all of our websites that help walk you through everything easily. You just got to stop and look at it.
Or watch the video.
Or watch the
She
video.
made a really good video, so just watch the video.
It's gone viral, hasn't it? 3 million views already?
Yeah,
Okay.
sure.
But you know, timelines are so important. Now, other states don't have the junk we got here. But I like to tell investors, guys, you got, you know, get the on a wraparound mortgage, get the Texas 7-day time frame running. Get your buyer simultaneously into the 𝐼𝐴, you said, right?
Right.
Yeah, get that part going. And as that's going, we're going to order the abstract again, because now the investor who bought it from a seller, we got to check him out.
Correct.
We've already checked the original seller, but they go, well, why are we doing it again? Because we have no idea what you got against you.
Right.
And things do pop up along the way. In fact, we just had a deal where it was a closed on like a Monday, or we did our title search clear, and a judgment lien got recorded like on a Monday, and we closed like on a
Yeah.
Wednesday. And that's where a lien pulls up in the gap time frame.
Right.
You know, we don't want a lot of time to be out there between the time we order the abstract and closing, because we can't order another abstract, and we can't order a bring to date on those. They're going to charge you every single time,
Correct.
Yes.
and the investor doesn't want to pay it. So it's important to get the abstract in and close reasonably quickly thereafter.
Right.
But initial 7-day period, get the buyer into the 𝐼𝐴 for loan processing, so that 10-day period is running. We can order our abstract almost immediately thereafter, which will allow us, and it's going to take a couple days to get that in. So all these time frames start to run concurrently and expire, and then once everything is clear to go, we can then get that closing disclosure, which is horrible. Guys, a closing disclosure, you know, takes about an hour to fill one out. There's so much information you need to garner from lender, title, docs, etc., to do it correctly. And let all this stuff run, and then get that CD out, the closing disclosure, and let that final time frame run. And you know, investors come to you, they go, well, why can't we close? Well, the CD has to go out. Well, why haven't you already done it? Well, we didn't have the information to do it with, because we didn't have the 𝐼𝐴 package, blah, 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 in order to fill it out and to get the stuff going. So again, that goes back to that knowledge base issue, I think, from the investor perspective.
Right.
You have to kind of know what is out there and why, to realize that there's some things you can't do until you've got all this stuff.
Right.
And you got to get it all put together out there. So, no, so what are we always say there's 4 things that they'll be thinking about in the way of compliance. Miss Lawyer, what are the 4 things we always want to think about from compliance?
The Texas Safe Act here in Texas,
With the SAFE Act, yeah.
yeah, Dodd-Frank.
Well, I'm going to stop you 1 minute about the SAFE Act, because here in Texas, no, it used to be a 5 property de minimis rule, now it's 3, because of Senate Bill 43 that changed that. But nationally, it's 1, meaning every deal You gotta do that, meaning every deal you've got to process your buyer, no options out there. So you got the SAFE Act,
Go RESPA.
you got good old RESPA. That's not us, is it?
Nope,
No?
that's not us.
Have you ever seen an investor provide their own RESPA disclosures?
No.
No, I haven't either. And by the way, I have never done it myself, and I don't wanna do it. That's why you use the 𝐼𝐚𝐼, because it solves that problem for you.
Right.
So, we got property code we already talked about. You said the SAFE Act, you said RESPA, and
Dodd-Frank.
good old Dodd-Frank. And, you know, to help the investor help themselves also with this, one of the things I know that we do different than anybody else is we actually look at their deal and their numbers to ensure that what they're charging in the way of an interest rate is compliant. Now, you go back a couple, 3 years ago when the APOR, average prime offer rate, was like 0 or 0.1 or whatever it was, almost nothing. You know, you had to be really careful because with higher interest rates, you were exceeding the APR that's allowable on these deals. And we'd have to call the investors and lock that down. Now today, not so much, because if you're doing a 30-year mortgage, you amortize the fees out over 30 years, and the APR might be 7.25%, 7.5%, plus the 8.5% on top of that. I mean, they can have an APR of 16%, which we ain't gonna see a 16% interest rate loan anytime soon, I don't think. If you do, I wanna know who's signing, because I want to be their lender. But you just don't see that, but we do try to look at those kind of things,
Yeah.
because you wanna look at that stuff. You need to have a little bit of a working knowledge of prepayment penalties.
Right.
What can or cannot you charge to stay compliant with Dodd-Frank along the way, and RESPA and all these things. Because investors, we want to charge a 10% prepayment penalty. Okay. We're going to tell you probably not is a good idea. Here's why. Now, if you want to charge it, as long as you hold us harmless from doing that, we're cool. But it's going to be fall on your shoulders to have that liability, because you can't do that.
And I don't think you can do it through the Texas Finance Code either.
No.
In Texas, I think you can only do 5%.
Well, there's some issues with Dodd-Frank, and I'm not gonna get into all this right now. This is talking enough about closing versus getting into all the compliance crap, but, you know, there's some issues of within the first 3 years and various things of that nature, what you can and can't charge to stay within the qualified mortgage status, or the rebuttable presumption status, which is where we wanna stay. We don't wanna get beyond that, because if it does, boom, it kicks you up to the next level. And once you're in that next level, you're getting your borrower out there in front of HUD to get a three-hour certification course of some type. Nobody wants to do that. So there's just little things you just gotta know these things, in this business, and learn them. And we're gonna try to help you understand it, right? So I got all of that. So you gotta get just a working knowledge of some of the basics.
Yep.
Know the state's property code. I don't care what state you're in.
Watching a few TikTok videos does not make you a real estate investor. There are people
Or
out
an
there
expert.
that watch a few
Wait a
videos,
minute.
and they are
Have you
ready.
seen the plethora of TikTok videos we got on there about this? No. But you're right, it doesn't. You do need to take the time and be learned in this. You don't need to be an expert in it, but you do need to know some of the basics.
Or learn it, watch the videos like from somebody that knows. Like you have all the videos, all the knowledge on available on YouTube for people to watch that has a lot of that information already.
Yeah.
So
Well, it's out there. You just got to get it and write it down and try to remember it.
right.
And it's hard to remember this stuff. There's a lot of moving parts sometimes, and I know even we sometimes gloss over some things and go, "Oops, got to go back and fix that," right? So I got all that. So how long does it take to get an abstract in normally?
You would know that better than I would.
About 3 to 4 days, depending on the county, depending on, I guess it's just really on the county, but it's 3 to 4 days.
Okay.
And if it does take longer, they'll let us know. There's usually an issue.
What about title insurance?
3 days, 3-4 days as well.
Yeah, 3 to 5 days is probably a good number to go off of. And you know, one of the things I see so many investors get flustered with is they don't understand some of the basics of title insurance in the creative finance world, such as if the existing debt is an FHA, VA, or home equity loan,
Right.
the great odds are you're probably not getting title insurance
Right.
because most title companies don't want to issue that. I've heard there might be somebody here or somebody there doing it. Haven't really seen that yet, but I've heard it might be out there somewhere. But that's just a business decision for these underwriters, not us.
Okay.
But if you want to get title insurance for your buyer, you can't get that, and you've agreed to provide it to them, you may now have a contract conflict somewhere that could be an issue.
Right.
And I know we just ran into that issue with a contract just recently that really got to be a pain in the rear.
Mm-hmm.
So again, knowing what you got so you can draft your contract better helps to facilitate this stuff and move it along and get us to the closing line out there. And of course, I think we just talked about the processing a little bit, right? We've already kind of kicked that around a bit, that you gotta get your buyer into that 𝐼𝐴. There's gonna be a minimum 7 to 10 day period from the time they get everything in.
Yes.
There's actually a 10-day period, first 3 days and a 7-day, but it's 7 days from the time that the loan estimate is issued by the 𝐼𝐴, which means they have to have all the information in from the borrower in order to complete the LE, as we call it,
Correct.
before they can send it out. And then you can't close for 7 days after that. And that's not our rule, that's federal.
Right.
You know, so you got those kind of things that pop up there. So I think understanding basic process procedure of getting deals into us, how long it's going to take to get title or an abstract ordered, what are the time frames for the 𝐼𝐴, what are the time frames for the closing disclosures, all these time frames. And they're not hard to remember. You just got to make sure you write them down and some overlap each other and then move on down the line and get it done. And then finally, we can get their deal closed, right? Which is problematic sometimes. What do y'all see as issues in the closing process? Anything?
On wraps, it just, I think the disclosure of that it's a wrap. We've come in with some of the issues, like we're closing at the closing table and we're explaining the disclosures and we're letting them know about the due on sale clause, things like that, and they're so confused, they didn't know there was an underlying lien. So I think just disclosing to the buyer the information that it's
So
going
that
to be a
sounds to me
wrap.
like the investor needs to make sure that he's explained things properly.
Yes.
Correct.
So one thing I see about that is the investor. So the investor may even know who brought the buyer to the table sometimes,
Right.
Correct.
and whoever brought the buyer to the table never explained these things.
Right.
And so they come to the closing table and they're going, "What?"
Mm-hmm.
So I think the key there is making certain that whoever the buyer rep is, for lack of a better word right now, is to make sure they have taken the time to explain things to the buyer what's happening.
Right.
You know, I know that oftentimes Tina and I volunteer to hop on a quick little phone call for 5 minutes with a seller, investor, and the back end buyer, walk through the quick process, answer a couple of quick questions, and go. Just make sure everybody's on the same page. But they have to reach out and ask us. We're not going to call them and go, "Would you like us to talk with your buyer for you?" No.
Right.
You know,
They tell
you gotta
us,
call
"But at
us
the
and
closing
ask."
table, can you just explain it to them at the closing table?
Yeah.
And you can't when they get up and walk out the door going, "We didn't know that."
We've
And
had
it
that
becomes
happen.
an issue, and it does happen sometimes.
Yeah.
And we want to avoid that like the plague that's out there. Now, just some little, tidbits too, is, when you do these deals, bad things happen to good people. I always often say, we're going to talk about bankruptcy for about that long, where, have you ever seen anybody who wants to file bankruptcy?
No.
Nobody wants to do that. That's horrible. Sometimes they do.
Right.
There are people out there who have nothing to lose by doing it sometimes. Most people do. But if they are given options, they don't have to do it. But, it does happen. Bad things happen to your buyer. They can't afford for making payments. They lost their job. Illness.
Especially in today's economy.
Yeah. Divorce, medical issues, all things happen.
Right.
That's just the nature of the beast that you have to be prepared to deal with out there. And when you're going through foreclosure, they could file bankruptcy.
Right.
And that's just not a good process, And I want the investors all to take time, although we could talk to them about some basic things, but it's smart to reach out to a knowledgeable bankruptcy attorney who is not necessarily a consumer bankruptcy lawyer, who represents the guys who file, but the one who's going to help you defend it properly. We've got some good ones here. We work with you in Texas. And by the way, bankruptcy is federal, which means it covers every state, right?
Nation.
Yeah, it covers every state, and you have to have a special license to practice there as well.
Yep. But they have that, they're able to do those things because they're licensed in those various courts.
Right.
We're not. You know, that's one thing I try to avoid like the plague is the bankruptcy stuff as well. I know enough to be dangerous, that's about it. But, you know, I know that if you get it filed, you gotta file a proof of claim. There's usually a 60-day period before a payment actually goes to the trustee and probably 90 days before you see that. And you can scream, holler, jump up and down all you want, and it ain't gonna change anything.
Right.
You know, but you have to be diligent also. You got to stay on top of it. And you know, whenever one of our clients files bankruptcy, you know, I don't try to handle this myself. I call our guys and I get one of them to handle it for us. Yeah, it's gonna cost me a little bit of money, but now I know that someone's gonna watch it. So if something happens, the borrower doesn't meet their deadlines, we can move to get the house back quicker. As opposed to waiting 2 or 3 months to find out I could have done that sooner.
Right.
And so by saving that interest carrying money that you're accumulating along the way, by doing this, it's oftentimes well worth it. So I like to tell everybody, you know, in this industry, you need access to good people who are good knowledge, who can help you through these deals. And it's okay to pay a little bit of money for it. No, if you're going, you gotta pay to play. Ain't nothing free, unfortunately.
Right.
You found anything free yet?
We had a free water burger. Buy one, get one free. That's about it.
Are you taking me? Is that a lunch invitation?
Yeah, if you buy one, get one free. You not got the
You
little
buy it so
coupons
she
in
can
there?
get it free.
Exactly. You're buying, I get one free.
That's how it usually
There
is.
you go.
Which isn't the problem. So just a quick little recap, guys. You know, in talking to the investors out there, what is it you want to let them know? I mean, that we want to do for them, get this thing done. Well, what's out there?
For the investors?
Yeah.
I mean, we want to help them. We're doing everything that we can to get them to the finish line. And we just want to help them help themselves.
But amazing how you built in the title there a little bit. But it truly is, isn't it?
Yeah.
Yeah.
And helping the investors understand the processes, all the processes, getting information in at one time. Number one, right?
Yes.
Make sure it's complete information,
Complete
not
information.
because I would better guess half the time it's not.
Probably more.
Yes.
Oh wow, I didn't know that.
Yes.
Yeah. I
And
would
that's
say
frustrating because we can't do
maybe
anything.
80% of the time.
Right.
Then it's emails and phone calls going back and forth,
Yes.
more time delays and more time goes by.
Yeah.
Yes.
So I get all of that. Good info. Understanding the procedures.
Right.
Step by step by step, buying and selling.
Right.
And again, did I say that that's all online at OFN, ownerfinancenetwork.com, and at Horne and Associates PC? Everything buying, selling, so you can follow through on this one by one. We're trying to put the resources out there because time is money.
Right.
And guys, if a deal doesn't close, nobody
Right.
makes money, right?
Exactly. Right.
So, you know, we want them to make money. That's the most important. You know, we want to close the deal because we want to make money. And we're all going to put the effort in to do it. We're not doing this to delay things.
Right.
That's the ultimate goal.
Exactly.
That's it. Because we want to help them. We want them
We
to
do,
close.
yeah.
Yes.
My favorite thing is if everything is in and I can look at a file and go, okay, yes, and draft documents and send it over for closing. I love those deals.
It's amazing how fast those can go, isn't it?
Yes.
I mean, it really is.
When was
I
the
get
last time?
When was the last time we had one
When
like
was the
that?
last time we had one like that?
Well, I think the problem with that is there's such an influx of investors into the marketplace.
Yeah, that's
They've
true.
all had this modicum of knowledge, but they haven't gained the full knowledge. But they're trying to do the deal, and I get that.
Yeah,
And they things get missed. They
Right.
get missed. They get missed. And then the finger point comes out. It's your fault. It's
Yeah.
your fault. No, time out, guys. It's really the investor's problem because you didn't get us what we needed, so we can help you help
Correct.
yourself.
Right.
Right.
Yeah.
Help
But I agree
me
that those
help
deals are smooth. They move quick. They're awesome that way.
I love it.
you. Yeah.
And it does.
I used to.
And they're really, when we get it all, they're pretty easy to do.
Right.
and we can get it knocked out quickly. But it's the start stop, it's not getting the full information, the changing of the terms constantly, the substitution of this for that, all these funky creative things. It's like, what are y'all doing? And then, you know, I'm seeing all this usury stuff pop up out of nowhere
Yes.
that I'm just going, we can draft all that. We just want you to be aware of X, Y, and Z. And so long as you agree to hold us harmless, we don't care what y'all do, but we've advised you, move on from there. Again, we're not their lawyers. I don't really care. But don't come back and point your finger at me because someone gets sued because they did something goofy and weird,
Right.
which is what we're trying to do, protect ourselves there a little bit as well.
That's right.
And that keeps building and growing more and more and more.
Right.
Yeah. Anything else you guys want to add?
No, you.
I think if the investors, if they just don't know, or their TCs or whoever they have communicating, we have a lot of people that communicate with us. Just be specific. We've had a couple of TCs recently that they're like copying Scott and Tina so everybody's in the same loop, and that's cool because then we can communicate one time as opposed to sending one email to Tina, one email to Sharon, one email to Scott. So that's good. But then also if they don't know, we've had some really good emails or phone calls where they'll ask questions, and I think that's good for them to ask instead of just waiting or assuming that the TC is going to do something. An investor called and said, well, I just want to make sure that I'm giving all the correct information of what we need. So just if they don't know, ask questions. We're going to answer them, but they need to, once we answer the questions, remember it for the next one. Apply it for the next one, because they're asking the same questions sometimes over and over again. But
No,
we're here to help them. We want to help them close their loans.
I get it. Now, I know I try, I know that Tina tries to take our staff here and really help you guys understand all the moving parts here. Because again, knowledge is power. The more that we know, it does make it easier for us to help the investor and the TC along the way with what they need and why. Because sometimes they just don't know what they don't know.
Right.
And again, I hate to keep using Texas as the example, but we are the stepchild of the industry. I mean, we are the 800-pound gorilla stepchild of the industry because we do it more than anybody else around here. But we also are more problematic and more issues that you just got to know.
Right.
And if you don't know it, what you don't know can hurt you.
Right.
At least here, in that regard.
And then also, we only know general information. If it's more specific, they're gonna need to speak with an attorney. They're gonna need to do a legal consultation if the issue is something that we can't handle.
You seem to roll my eyes on that one real quick. Yeah, and again, what's the problem with that?
They don't want to pay.
No one I mean, I get it. They want free information, and it's just, I would love to be able to do that for everybody. That's why we've done so many buku, or whatever that number is, buku, videos about all of this stuff that they can go to and get what I hope is really good, quality, legitimate information about this industry.
Right.
To help them buying, selling, and everything else
Good
in between,
videos
right?
too, with good information.
Of course, you're in them, aren't you?
They don't. Well, no, I'm in one. That's good. But a lot of the times they don't watch the videos and they want to speak with somebody. But I'm saying we as in like me, like we're not attorneys, so we can't answer those questions. And the
Don't you
minute
play
that
one on TV or something?
yes,
Okay.
it's my side job. But we can't answer them, and so when we refer them to a legal consultation, sometimes they do get upset.
And I agree. I see that often out there where they are asking, and I know why they do that. They don't know the difference. I know you want to help, and you may know the answers, but we got to be so cautious not to step over that
Correct.
line of practicing law without a license. Some people do out there. I get it. Go for it. We just got to be careful up here because things do happen along the way.
Yeah.
And again, it's about how can we better help the investor,
Right.
help themselves out there. Anything else before we wrap this puppy up? Everybody good?
Yeah.
Anybody bring the cards? No? The free beer? No? Okay. Hey guys, I hope that helps everybody out. Thank you for taking the time just to listen to this a bit. I hope it helped everybody understand some of the processes, some of the issues that we see out there with these deals, because truly our goal is to help the investor help themselves move these deals along fast and quickly to closing. It allows us to do so many more deals over here, helps you get to that finish line so much faster out there. Own that property, get it income producing, close that deal, put money in your pocket, whatever it might be. but time is money, and we're here to help you get that deal closed. And again, you know, if things happen and it doesn't close, we know that no one makes any money. That includes us. So we're not the bad guy. We're really trying to be the good guy to help these deals get put to bed as fast as possible.
That's right.
If you got questions, take a minute, reach out to us here at theownerfinancenetwork.com or Horne and Associates PC at hornerealestatelaw.com, and we'll look forward to seeing you guys next time.
Wait a second, Scott. You got some questions. I think the other people can go though. This is getting out so fast. Somebody wants to know.
I'm so hot.
Cecilia wants to know. Talking to a realtor, he was open to listen to about subject to wraparound mortgage. His main concern is when, if the seller is in the second position and have a promissory note, how are they protected from you not paying the mortgage?
So you bought a home subject to the existing debt, and there's a second lien back to the seller also.
Yeah.
Okay.
With the promissory note.
So to answer that question, so when a property is bought subject to, we are always going to give the seller back a deed of trust, which is their security protection. So in case we don't make the payments, they have a traditional mechanism, i.e. foreclosure, to regain ownership of the property. They can also, if they have a second lien, there's going to be a deed of trust that they can foreclose under as well. So they could foreclose under either one of those two deeds of trust in order to regain the ownership of the property and make sure that they're protected.
Okay, and somebody asks, who puts the power of sale clause in the mortgage or deed so that we can protect the seller and let them know if they can foreclose on us?
Okay.
In case.
So the power of sale clause out there is a standard clause in pretty much all deeds of trust. You know, in Texas, we have state promulgated forms of that format put out by the State Bar of Texas. It's in there. And in a Freddie and Fannie standard deed of trust, it's in there automatically. And if you're looking at a document and it doesn't look right or wasn't prepared by an attorney per se, which I hope it was, read it and look for that specific language to ensure that it is in there. I have actually seen investors who draw up their own notes in deed of trust, give it to the seller and or to their lenders sometimes, and the documentation is completely wrong and leaves out all of these items along the way. So it is very wise to know what to look for. It's a great question, and it only takes a moment to look in the document to make sure that that clause is in there.
And final question is, how do you manage insurance and subject to?
How do you manage insurance and subject to? Boy, have we done that 318 times. We did that Monday.
Check
Let's
out our Monday live stream.
check out our Monday live stream. Well, let's talk about it one more time though. So when you buy a home subject to the existing debt, you want to see the seller's original insurance policy because you're going to need the lost payee clause that is on there. Next, as you're buying it sub to, the real question becomes, what are you going to do with the property? If you're going to live in it, if you're going to fix and flip it, if you're going to do a rental of some type, long-term, short-term, whatever it might be, maybe you can simply be added on to that existing policy as a co-insured. If not, in those cases, I suggest you get your own insurance policy, which yourself as the owner and the original seller are named insureds, and that the mortgage company becomes the primary and only lost payee. Pretty easy. You might consider using a land trust in those scenarios, which the trust becomes the primary insured and the seller the additional insured, same as the time before that. Now, if you're going to buy that property subject to, if your goal is to do a wraparound mortgage, knowing that you're going to sell that property usually pretty quickly, that's where things become a little bit of an issue because we don't want to keep changing that policy over and over and over again for the mortgage company. And there's not a right or wrong answer here either. And sometimes it's just best to ask your insurance professional how they would handle it the best way. But you may want to get added on as a party of interest while you're in that construction phase, marketing phase. Then your back-end buyer is going to get a new policy in which they and the original seller would be the named insureds. The mortgage company is the primary loss payee, and you, as the investor selling the home, would be the secondary loss payee in that scenario. So taking some time, checking out some of our videos also, go through this in a lot of detail for you, and hope that helps you out on insurance.